What actually happens if someone dies without a will in Florida? So let's talk about it in a simple, practical way so you know exactly what the law does when someone leaves no instructions at all. When a person dies without a will, Florida calls that dying intestate. And here's the part most people don't realize. If there's no will, your family does not get to decide who gets what. You don't get to decide who gets what. The state of Florida decides. Florida has a strict legal formula for dividing assets. That formula doesn't care about family dynamics. It doesn't care who you were close to. It doesn't care who did your caregiving. And it doesn't care who you always said you wanted to get what. It goes by the statute, period. And many times those results shock families. The first question Florida asks is simple. Was the person married at the time of their passing? If they were married and all of their children are from that marriage, then the spouse gets everything. Pretty simple. But here's where things get complicated. If the person had children from a different relationship, even just one child, everything no longer goes to that spouse. In that situation, the surviving spouse gets 50%, half, and the children, all the other children, split the other half. Now, I've had many blended families in my office who were completely surprised by this. A lot of the people assume their spouse automatically gets everything, but under Florida law, that is simply not guaranteed unless there is a will or a trust saying so. Now, what if the person was not married? Florida moves down a very strict priority ladder. Everything goes to the children first, right? So you're not married. Who are your kids? It goes to them first. And if there are no children, then everything goes to the parents. So we go down to kids first and then up to parents. If the parents are not alive, it then goes sideways to the siblings. And if there are no siblings, it moves to nieces and nephews and then further out to the extended relatives. And here's the part that surprises families the most. Estranged relatives inherit just like the close ones. So if you have a sibling you haven't spoken to in 20 years, Florida law does not care about your relationships. It cares only about bloodline. Now, let's talk about minor children because this is where things get even more complicated. If someone with minor children dies without a will, Florida does not allow those minor children to receive money directly. Instead, the court is going to step in and the judge controls how the money is managed, who manages it, and how it can be spent. Every dollar has to be supervised. And depending on the situation, the person chosen to manage the money might not be the person you would have wanted. And when those children turn 18, they receive whatever is left all at once, whether or not they are ready for that responsibility. A properly written will or trust, I should say, not a properly written will, a properly written trust completely avoids that. Now, here's something most people absolutely do not realize. In Florida, unmarried partners, even if you've been together 5 years, 10 years, 20 years, but you're not married, your partner will inherit nothing if there is no will. Stepchildren will inherit nothing. Fiancés, nothing. Best friends who were like family, nothing. Even if everything was said out loud, if everyone knew, like, oh, when I die, I want my, stepson to get or stepdaughter to get everything, or I want my bestie to get everything. If there is no will, that person gets nothing. If it is not written in a legally valid estate plan, Florida treats those people as strangers. I see this situation often, especially with long-term relationships where the couple never legally married. Without a plan, your partner will be left out and they'll get nothing. Now, another issue that comes up when there is no will is the question of who actually becomes the decision maker. The person Florida calls the personal representative, or what many people think of as the executor. Without a will, you don't get to choose who handles your estate. Florida has an order. First, the spouse, then the majority of heirs, then the closest relatives, and if they cannot agree, the judge will decide. And if there's tension in the family, which is often the case, things get messy very quickly. Let me give you a quick Florida example. Imagine David from Fort Lauderdale passes away without a will. He's been married for 10 years, but he also has a grown son from before the marriage. Under Florida law, David's wife receives half of the estate, his son receives the other half. Even if David always said, everything I have is for my wife or everything I have is for my son, the law doesn't care about verbal wishes. It cares about what's written, or in this case, what's not written. And this is the one situation that leads to more family conflict than you can imagine. This is why so many families end up fighting when someone dies without a will. People argue about what the person wanted. Relatives appear out of nowhere. One person feels entitled, another person feels cheated, and the judge must follow the statute, not the emotions, not the memories, not the conversations. And the process becomes longer, more expensive, and far more stressful than it needs to be. The good news is all of this is preventable. A properly written Florida will puts you in control. A revocable living trust can help your family avoid probate entirely, and clear beneficiary designations can make transfers simple and private. Estate planning is one of those things that feels complicated from a distance, but once you take the first step, it becomes very manageable, and it gives you and your family so much peace of mind. If you learned something today, or if you want me to answer your question in a future episode, drop it in the comments or send it to me directly. I'm Attorney Otto. Plan wisely, live confidently, and I'll see you next time.